Good morning. Today we'll discuss part 3 of the Indian Constitution. Of course, it's a larger one. We'll be taking some time, but we'll initiate the discussion today. So, part 3 of the Indian Constitution talks about the fundamental rights. As we have seen, each part is nothing but group of articles. Similarly, part 3 also consists of articles 12 to 35. Very frequently asked question in the examination. So, at the time of discussion of the fundamental rights in the Constituent Assembly, Dr. B.R. Ambedkar said it. This is the most discussed, this is the most criticized part of the Indian Constitution. When he said criticized part of the Indian Constitution, he means that so much of discussion has been taken place for the discussion of fundamental rights. What is the basic idea? See, before the independence or before we commence our constitution, there is nothing like any fundamental rights that were existing in India. That's the reason the constitutional framers wanted to frame the Constitution of India in such a way so that every citizen living in India will be living with certain basic rights. Hence, the fundamental rights are nothing but the basic rights of the citizens. I told you one point in the previous class that the concept of basic rights was borrowed from American Constitution. In that Constitution, it is called Bill of Rights. In India, in our Constitution, we are using the words the fundamental rights. And these fundamental rights are the part of the Indian Constitution since beginning. That is the reason the original Constitution constitutes and it talks about the fundamental rights. But there is a difference here. The original Constitution was talking about 7 fundamental rights. But in today's Constitution, we have 6 fundamental rights. Meaning, there was a fundamental right called right to property. And that right to property was deleted from the list of fundamental rights through 44th Amendment. This happened in the year 1978. So as of today, so we have 6 fundamental rights in the Constitution. At the same time, can I say that our fundamental rights are absolute? When I use the word absolute, that is nothing but final. Our fundamental rights that are enshrined in the Constitution of India are not absolute. Meaning at every point of time, we cannot enjoy the fundamental rights. Kindly see here, any constitution anywhere in the world is made in such a way that it should be providing and giving highest importance to the security of the nation and to the security of the people. For that reason, deliberately, even the fundamental rights that are mentioned in the Constitution can be suspended because of certain emergency situations. Not every time. That's the reason why in Indian Constitution we have a concept called emergency. It's called emergency provisions, and one of the emergencies is that national emergency. So during the time of this national emergency, certain fundamental rights can be suspended. Even under normal circumstances also, certain rights will be suspended. Meaning, the fundamental rights are not absolute. What are they? We'll have a discussion one after the other. But the fundamental rights will play a crucial role with respect to the lives of the people in the country. Without enjoying the fundamental rights, there is no meaning. That's the reason why Dr. B.R. Ambedkar has given highest importance to the concept of the fundamental rights. He has given highest importance to Part 3 of the Indian Constitution. And I told you the number of articles, 12 to 35, they talk about this fundamental rights. And out of these 12 to 35 articles, Dr. B.R. Ambedkar has given highest importance to an article called Article 32 of the Constitution of India. Article 32 talks about the constitutional remedies. What do you mean by this? When I use the fundamental rights, the words fundamental rights, these fundamental rights are guaranteed for every citizen, and the state cannot violate these fundamental rights. When I use the word state, kindly recollect the meaning of the state, what I told you in the previous classes. Parliament of India, Government of India, so many things I told you. Just recollect those points. And against the state, a citizen has every right to approach the court. The state has every right to make any legislation in India. But whenever you make any legislation, you have to make a legislation in such a way so that our fundamental rights are not infringed. By giving highest protection to the fundamental rights, you can make any legislation. But whenever those fundamental rights are violated because of any legislation that is made by the state, that is considered to be violation of the fundamental rights. During that time, what will happen? A citizen of India has every right to approach the judiciary under Article number 32 of the Constitution of India. That is the reason why Dr. B.R. Ambedkar has given highest significance to Article 32. We'll see all the points one after the others. I was telling you some time back when I was explaining you the meaning of the word state. The meaning has been given by the Constitution in Article number 12. And when it comes to Article number 13, I was also telling you there is a concept called judicial review in India, and the concept of judicial review has been borrowed from American Constitution. During the time I emphasized and am reiterating now, the words judicial review are nowhere mentioned in the Constitution, but they are implicitly present in the Constitution, that is in the form of Article number 13. Kindly remember, the words judicial review are nowhere mentioned in the Constitution, but the concept is implicitly expressed in Article number 13. Under Article number 13, the state has every right to make a legislation, but they should not infringe the fundamental rights of the citizens. That is the basic idea. And now I am going to talk to you about all the 7 fundamental rights. And after that, we'll see the fundamental right which has been deleted through 44th Amendment, that is right to do property. And later we'll have a detailed discussion about each and every fundamental right that is available to the people in the country. Let me have a list of this. First of all, starting from Article number 14 up to Article number 32, we have the list of all the fundamental rights. Like we have a right to equality, right to freedoms, right against exploitation, right to religion, right to culture and education, right to constitutional remedies. And before the constitutional remedies, under Article number 31, we have right to property. Of course, right to property, I'm deleting it. But at the end, if I go here 32, I am talking about right to constitutional remedies. Now we'll have a discussion one after the other. Kindly see here, from fundamental rights, the questions are appearing in both preliminary examination and also in the main examination. This is one important aspect as far as civil services is concerned. This is one important aspect during our general discussions with respect to the current affairs. Very frequently, whatever the articles I am going to talk to you, they will become the part of our discussion, even during the current affairs. Once you understand the concept of the fundamental rights, tomorrow if any news appears in the newspaper, it becomes so easy for you to understand. Why the judiciary is coming to protect the rights of the people, what the state is doing, and what the judiciary is doing. We'll be understanding each and every point now. Now, when I say each fundamental right, for example, right to equality, the concept of right to equality is mentioned under Articles 14 to 18, meaning Articles 14, 15, 16, 17, and 18. So these 5 articles put together is called one fundamental right. Meaning, whatever I am going to talk to you under article number 14, 15, 16, 17, or 18, at the end of each article, the essence is providing the right to equality. Every citizen is equal before the law. Nobody is above the law. That is the basic idea in all the 5 articles that I am going to talk to you now. Kindly remember, all 5 articles put together is called right to equality. The subject matter that is present in each fundamental right, in each article under right to equality, is different from the other articles. But at the end, the essence of each article is nothing but providing the right to equality for all the citizens. Okay, this is how we are going to go ahead. So when I come to right to freedoms, I will have articles from 19 to 22, meaning 19, 20, 21, and 22. These 4 articles put together, this is called a right to freedoms. And after that, we see right against exploitation, where I have 2 more articles. One is the article number 23 and article number 24. These 2 articles put together is fundamental rights. Next, articles 25 to 28 put together is called right to religion. Hence, articles 25, 26, 27, 28. These 4 articles put together is called right to religion. Next is the right to culture and education, that is mentioned under articles 29 and 30. Right to property under article 31. Right to constitutional remedies under article number 32. Like this, we have all these things. And the content of 33, 34, 35 we'll see at the end. But let's try to understand what exactly is the Constitution is talking about this. And another point I would like to tell you now itself. The Constitution is applicable for all the people who are living in India. Whether a person is a citizen of India or he is a non-citizen, he is coming under the clutches of the Constitution of India. And in that Constitution, because we have the concept of fundamental rights, these fundamental rights are also applicable equally for both citizens and non-citizens. Meaning, a non-citizen is also has every right to enjoy the fundamental rights that are enshrined in the Constitution of India. But certain articles in the fundamental rights, they are exclusively applicable only to the citizens and not applicable to the non-citizens. Hope you are getting me. And those articles are articles 15, 16, 19, 29, and 30. These are the 5 articles which are exclusively applicable only for the citizens, and the non-citizens, they cannot enjoy these articles. Am I clear? And when we come to the topic, we will try to understand. When I come to article number 15, I'll tell you this is the article that is exclusively applicable only to us, not to the non-citizens. Article 16 only for us. 19, 29, and 30, these are exclusively applicable only for the citizens and not to the non-citizens. We'll try to understand when it comes to that particular topic. Now, let me open the document. Let me start giving you the explanation regarding the each and every one. Okay, hopefully you understood all the points what I have covered so far. This is important for understanding the whole concept of fundamental rights. Am I clear? Now I will open the document. I'll share the document and very fastly we'll go through this. Okay, kindly remember we are going to spend some time on this article, on this subject topic, fundamental rights. Hence, have lots of patience and have complete concentration. Then only the subject will be going into our brains, which is very, very important for achieving IAS. Now, let me open the document here. Look at this. Fundamental rights. This is the mentioned in part 3 and articles 12 to 35. Kindly remember this range. These are mentioned in part 3 of the Indian Constitution. These were borrowed from the United States Constitution. This is considered to be the Magna Carta of India. According to Dr. B.R. Ambedkar, it is the most criticized part of the Constitution. Most criticized means most discussed part of the Constitution. Next, when you look at this one, these fundamental rights are justifiable. Let me make a point here. I am using the word the fundamental rights are justifiable. When I say it is justifiable, on the grounds that our fundamental rights have been violated, the Constitution is giving the right to the citizens to approach the judiciary. And the top courts in India will come to the rescue of the citizens when it comes to the violation of the fundamental rights. Am I clear? That's the reason why, kindly remember, fundamental rights are justifiable. Fundamental rights are justiciable. Meaning, if there is any violation of any of my fundamental rights, we have every right to approach the judiciary. Okay? Along with the examples, I'll be discussing with you all these things. Now, that is the meaning of the justifiable. Kindly remember this. Look at this. In the original Constitution, 7 fundamental rights are mentioned. Yes, we know this particular part. Now, look at this. Each one, and I want you to remember all these things for the examination point of view. Why it is important? Number 1, this is important with respect to the main examination. You may be asked to explain about each and every one. Number 2, when it comes to the preliminary examination, instead of asking about the what is article 14, 15, 16 here, we have seen the questions, and the questions are being asked in the form of match the following. For example, they will give you list 1 and list 2. In the list 1, they will say right to equality, right to freedoms, something. So all these rights will be mentioned in the list 1. Like UPSC may take 4 rights or 5 rights here. On the other side, the UPSC will give you the list 2, where the range of the articles is given, like 14 to 18, 19 to 22, 23, 24, like this. And you'll be asked to match this. Once you match it correctly, so you will be getting a mark. This is how you need to concentrate on how to remember this. This is a particular range of the articles which are associated with each fundamental right. Am I clear? Look at this. This is the first one, right to equality, right to freedoms, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, which is no more available, It has been deleted through 44th Amendment. And the last one is the right to constitutional remedies. So these are the 7 fundamental rights we had in the original constitution. But kindly remember, very frequently asked question, which of the following is not a fundamental right? Answer will be a right to property, and it has been deleted through 44th Amendment. Okay. Now, so I'm still going further here. Let me show you some more points. In the year 1978, through the 44th Amendment Act, right to property was deleted from the list of the fundamental rights. It has been deleted. But now, if you look at this particular right to property, it is a legal right under Article 300A in Part 12 of the Constitution of India. Meaning this right to property is still available, but not as a fundamental right, but as a legal right that is available where? That is available in under Article 300A, and which is a part of the Part 12 of the Indian Constitution. Look at this. The number of fundamental rights are 6 in the present day Constitution. The state can impose restrictions on the fundamental rights. So this is one important point I would like to highlight. If you look at the statement that is present in the brackets, the fundamental rights are not absolute, but they are qualified. What do you mean by this? When I am saying not absolute means at every given point of time, I cannot enjoy all the fundamental rights. Because the state, kindly recollect the meaning of the state. The state has every right to impose restrictions on the fundamental rights. That's the reason why they are called, they are not absolute, but they are qualified. Look at this. Except the fundamental rights that are guaranteed under Article number 20 and 21, remaining fundamental rights can be suspended during the operation of the national emergency. This will be understanding later over a period of time. First of all, we'll see what are these fundamental rights. We'll try to understand one article after the others. Then after a period of time, we'll be learning national emergency. Then we'll link up these two topics and we'll try to understand this one in a better manner. But directly remember one thing, the fundamental rights that are guaranteed under 2 articles, Article number 20 and Article number 21, they can be suspended when? Only during the operation of the national emergency. Kindly remember this. Next, when it comes to Article number 19, when it comes to Article number 19, look at this. Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression and not on the grounds of the armed rebellion. Okay, we'll understand these points again when we come to the national emergency. But remember one thing, whenever the national emergency is declared, the first article which is going to be suspended is Article 19. Article 19, just like any other article under the fundamental rights, is considered to be very, very important. This article talks about the freedom of speech and expression. We'll try to understand now. Now, we'll try to look into these articles and we'll try to understand and we'll have an explanation regarding each and every one. Okay, as I told you, I am going to talk to you regarding each and every article that is present in the fundamental rights, and we'll have a very, very, very detailed discussion of this each one. Is it okay? But what I will do is that today I'll just go through all the fundamental rights that are enshrined in the Constitution of India very fastly, so that let's have a overview of all the fundamental rights, so that it becomes easy for you to understand when I go into the details of this. And one more important suggestion is that I will have a discussion regarding all this now, one after the other. I'll try to cover all the 6 fundamental rights. Okay. But my suggestion is that today itself, whenever there is a possibility, kindly go through the video again. Kindly go through the same video again one more time. Because tomorrow morning, I will have a detailed discussion with you, each and every article, each and every class, each and every subclass. You will be understanding the concept of whole concept of fundamental rights tomorrow completely, provided if you followed my class today. Without today's class, tomorrow's class will become very difficult. That's the reason why I am trying to make it an overview. Though I am using the word overview, it will be a complete discussion. And tomorrow, whatever I am going to link is nothing but each class and subclass that is mentioned under the fundamental rights. I am going to have a discussion. Is it okay? This particular provision generally in the outside classes, wherever we take, maybe by any faculty member, it's really difficult. It is really difficult for them, or even for me also. If I go outside and teach somewhere, it is really difficult to cover each and every article class by class. Since we are going for this online training here, there is an opportunity for me to have a detailed discussion for regarding each and every article, classes and subclasses. Let's make use of this opportunity. Since you are there with me and sitting with me, along with me, with lots of patience, kindly make use of this particular provision and take the advantage of this. Try to earn more knowledge. That will be really helpful for us to crack the examination. Am I clear? Now, so let me come back to this topic here. I'll open the document. I'll go by the sequence, one article after the other, right? Now, just stay on with me. Look at this. Article 12 explains the state. And whenever we use the word state, we already seen this. The state includes the government and the Parliament of India. I need not explain you at this stage because you are thorough with this. The government of India and the Parliament of India, the government of the state and the state legislature, all local authorities, meaning municipalities, Panchayati Raj, district boards, etc. Other statutory and non-statutory authorities, we know what is the meaning of the statutory and non-statutory authorities. Okay, now I'm still going further. Look at this point. Look at this point. This point is very, very important. Under article number 12, we understood what is the meaning of the state. And in continuation to this, please understand the lines that I have highlighted on the screen. The actions of the state. Excuse me. The actions of the state can be challenged in the courts as a violation of the fundamental rights. Very, 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 very important. Okay. So that is the reason why when the government cannot do anything and everything according to its wishes, but whenever we feel that this particular action of the state is infringing our fundamental rights, we have every right to approach the judiciary. Okay. And the actions of the state can be challenged in the courts as the violation of the fundamental rights. Look at the next one. Article 13. This is very, very important for me. This is the place where the concept of judicial review has been mentioned implicitly. All laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. What do you mean by this? Just now I told you, the parliament has every right to make a law. State legislatures will have every right to make a law with respect to the subjects that are present in their jurisdiction. Kindly recollect again: union list, state list, and concurrent list. Within their jurisdiction, both central government, meaning both parliament and the state legislatures, they are making the laws. They are very much permitted. There is no objection. Constitution is giving them all the rights. But whenever they make any law, and if that law is contradicting with the fundamental rights, then we have every right to approach the judiciary, and the judiciary will nullify those laws which are made by the legislatures. That's the reason why if parliament or the state legislature makes a law, that is not final. Citizens should be given the highest importance. Protecting the fundamental rights is very, very important, and the judiciary is coming into the picture in the form of article number 13. Am I clear? Because the judiciary is coming, it is reviewing the laws that are made by the parliament. We are using the word judicial review. Deliberately we have avoided using the words judicial review within the constitution. If we use the word judicial review in the constitution, we will be giving most important powers to the judiciary. Judiciary will become supreme. But in India, there is nothing like any supreme authority. The powers of the government have been divided between legislature, executive, and the judiciary. All of them have been placed side by side, so that is considered to be the separation of the powers. Whenever I am using the word separation of the powers, these three institutions, legislature, executive, and judiciary, they'll be working like a checks and balances. Each organ is expected to function within its jurisdiction. But if somebody is violating any of the rules that are mentioned under the constitution, the other organ will have every right to check and balance the organ which is violating the procedures. That is the reason why article number 13 is coming into the picture in order to review the legislations. And it will review the legislation only to check that whether the law that is made by the parliament or the legislature at the state level, they are violating any fundamental rights. If it is violating any fundamental right, then the judiciary will have every right to declare that law as null and void. That's it. That is the meaning of this. Am I clear? Now, let me open the document. Look at this. All the laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. Now look at this. The articles expressly provided for the doctrine of judicial review. This power is conferred to Supreme Court under article number 32 and High Courts under article number 226. And they can declare a law unconstitutional and invalid on the grounds of contravention of any of the fundamental rights. This is important for us. Meaning, if we feel that there is a derogation of the fundamental rights or the law is inconsistent with any of the fundamental rights, where can we go? We can go to the Supreme Court or we can go to the High Courts. We have been given the powers to move the Supreme Court under article number 32 and the High Courts under article number 226. And the courts have every right to declare a law unconstitutional and invalid on the grounds of a contravention of any of the fundamental rights. Am I clear? Now we'll look into each article here. First one, we'll see the right to equality, where I have 5 articles putting together. This is called a right to equality. Am I clear? Now let's try to understand one after the others. Look at this. Article number 14 talks about the equality before law and equal protection of the laws. Meaning is simple. Sometime back when I was talking to you regarding the sources of the Indian Constitution, I was telling you there is a concept called rule of law. That is nothing but equality before law. And the concept of rule of law was borrowed from UK Constitution. These points we know. But in the article number 14 today, we have two phrases. One is saying equality before law, and other one is saying equal protection of the laws. Kindly remember, these two different phrases, they have been borrowed from two different countries. Equality before law is from United Kingdom and equal protection of the laws from America. Kindly remember these two. By mixing these two, we have our article number 14 in the Constitution of India. Now, let me show you the document again. Look at this. Look at this. Equality before law. The meaning of equality before law is nothing but it is the absence of any special privilege in favor of any person. There is an absence. There is no special privilege to any person in favor of any person. Meaning everybody should be treated equally before the law. Similarly, when it comes to equal protection of the laws, what do you mean by this? This is the equality of treatment under equal circumstances. What do you mean by this equality of treatment? Whenever the circumstances are equal, the citizens should be treated equally. Don't go for a concept of discrimination. Discrimination is not at all permitted. Favoring a person is not permitted. When the circumstances are equal, treat the people equally. That is called equal protection of the laws. One is the equality before law. Second one is the equal protection of the laws. These two concepts were borrowed from two different nations. One is from UK and second one is from United States of America. Am I clear? Next one. I'm talking to you about here. I'm just giving you the overview of these articles, and in the next class we are going to have a detailed discussion. But remember this, I want you to remember equality before law and equal protection of laws where it is mentioned. That is article number 14. What is equality before law? What is equal protection of the laws? Kindly understand these points today, and in the next class we'll go for a detailed discussion. Now look at this. Next one is the article 15. Look at this. Article 15 is saying that prohibition of discrimination on the grounds only of religion, race, caste, sex, or place of birth. What do you mean by this? When I'm using the word prohibition of discrimination. Discrimination is nothing but treating the people on the basis of a particular factor. That factor may be religion, race, caste, sex, or place of birth. What do you mean by this? If the state starts giving priority to a particular religion and it is not giving importance to other religions, that is called discrimination. But the Constitution has prohibited the discrimination, meaning every citizen who is present in the country, every person who is present in the country should be treated equally, and there is a prohibition of discrimination. Am I clear? Very, very important. That's the reason. Look at all the points. Religion should not come into the picture. Race, caste, sex, or place of birth should not come into the picture. But there are certain exceptions. Exceptions are nothing but special provisions for the children and women can be given. Clear? Since beginning, the children and women are given importance, which was absent during the British rule. That's the reason why special provisions for children and women they can be given, meaning discrimination is permitted in this particular case. It's an exception. Similarly, socially and economically backward sections can be given the priorities in certain sections. Kindly see here, if you look at the scheduled caste and scheduled tribes, these are considered to be the backward sections of the society. Obviously, what will happen on the name of no discrimination, if you start treating equally, the benefits will be going to the advanced sections and the backward sections equally. If the benefits are going equally to both the sections, when these backward sections will reach to the level of the advanced sections. That's the reason why the Constitution has deliberately permitted for the exceptions. Special provisions can be given to the children, women, other backward classes, scheduled castes, and scheduled tribes. So these are the categories who can be given the special privileges. What do you mean by this? The meaning is nothing but in article number 15, the Constitution is saying that prohibition of discrimination. Don't take any factor into consideration. Treat everybody equally. But the same article is also giving certain exceptions to certain sections of the society. That is the reason one of the criticisms against the Constitution is that Constitution is giving something on one hand and the Constitution is taking away something from the other hand. It's a criticism, but the ideas of the constitutional framers was really noble. They understood until and unless certain sections cannot be given the special privileges, we cannot look their advancement. In order to bring all the people up in the ladder, so that the people who are considered to be backward will also join the mainstream. In order to make them to join the mainstream, you need to provide special provisions. That's the reason why the Constitution has given the concept of the exceptions. Since it is mentioned within the Constitution, that is not the violation. That is not the violation. Am I clear? Next one. Next one, I'll open the document again. Come on, have a look at this. Look at this now. Article 16. Look at this. Article 16 is talking about the, kindly see here, I am talking to you only about the right to equality. Now look at this. Article 16 is talking about the equality of opportunity in the matters of public employment. In the matters of the public employment. What do you mean by this public employment? When I use the word public employment, these are the employment opportunities under the government. Maybe the central government, maybe the state government. There should be no discrimination and the opportunities should be open for all the people equally. That is a basic idea. Okay. And this particular article is providing the opportunities, equality of the opportunities in the public employment. This is one. But look at the same article in some other class, that is Article 16, Clause 4. It empowers the state to make special provisions for the reservation of appointments or posts in favor of any backward class of citizens, which, in the opinion of the state, are not adequately represented in the services of the state. What do you mean by this? See here, kindly remember this one. When I'm using the word equality of opportunity in the public employment, all the people who are appearing for the employment opportunities should be given equal priority. But here, if you look at India, we have the concept of reservations. Reservations are given for scheduled caste, scheduled tribes, other backward classes, and in most of the states, the women are being provided with the reservations. How are they being provided? See, Article 16 is talking about equality of the opportunity, but the same article is also giving an exception. It is because of the same meaning. As long as you start dealing with the people equally, it becomes very difficult for the backward section of the society to move forward. So that the gap that is present between the advanced section and the backward sections will be like this. If you start giving the priority to equally, even after 10 years, 20 years, or 50 years, the same gap will be maintained. And one of the principles in the constitution is that reduce this gap. How do you reduce this gap? Provide opportunities to the lower sections, that is the backward sections, and over a period of time, allow them to reach up in the ladders. And after a period, they join the mainstream. Then you can start treating them equally. But until and unless the people are not equal today, providing equal opportunities does not carry any meaning. That is the reason why reservations are very much permitted in India. The constitution is permitting this. And the constitution is making it very, very clearly that as long as the government feels that the backward sections of the society are not adequately represented in the public employment, the state can keep on providing the reservations. This is what is the constitution regarding the public employment. Am I clear? Next. Next, I'm going to the next one here. It is the article number 17. It talks about the abolition of untouchability and prohibition of its practice. Look at this. What is the meaning of this? Abolition of untouchability and prohibition of its practice. The concept of untouchability was very much in vogue in India. It was present from the times immemorial. And especially when in India, when Zamindari system was there, this particular untouchability concept reached the peak, in fact. And the people like Mahatma Gandhi and Dr. B.R. Ambedkar, these are the people who fought against the concept of untouchability. And the constitution, under article number 17, it has abolished the practice of this. If the practice of untouchability is existing in the country, then how can you ensure the concept of equality? In order to ensure equality, right to equality, untouchability has been abolished. And its practice in any form has been completely prohibited. And in order to give effect to that one, the Parliament has passed the Untouchability Offences Act of 1955. Meaning, under this Untouchability Offences Act, the people who practice this untouchability will be punished. Meaning, if somebody violates a law that is mentioned in the Constitution, the Parliament should come out with other legislation, like what type of punishment should be given to such type of people here. And if you look at in the year 1976, this act is renamed as Civil Rights Act of 1955. Originally, it was called Untouchability Offences Act. Now it is called Civil Rights Act of 1955. Okay. Now, look at this next one. Next one is the Article 18. This Article 18 talks about the abolition of the titles except military and academic. What do you mean by this? For example, see, during the British rule, so many titles were given to these Indians. It seems that the British continued in India for a long period because there was a continuous support and cooperation from some of the individuals in India. Maybe they might have thought that the presence of the British will improve the conditions in India, maybe in the form of education or economy. We don't know what their ideas were. But by getting impressed with those people, the British has granted so many titles to them. But with the commencement of the constitution, all the titles that were given, that were present before, every title was abolished. As long as the titles are there, they may be using these titles as a surname, and they may be thinking that they are elevated people in the society. Whenever somebody feels that they are elevated, obviously, where is the concept of equality before law? In order to ensure equality before law, the constitution has abolished all the titles. That's the reason why by January 26th, 1950, once the constitution comes into force, every title that was present in India, they were abolished. Even today also, the constitution is permitting the military and academic titles. That's the reason why in the military services, titles are given by looking at the contributions they are made, by looking at the bravery of those people for protecting the nation. Similarly, in the academic also, in the academic fields also, the titles are given. That is for recognizing their talents with respect to the academics. Apart from this, remaining other titles are not permitted. But in India, we have some awards called civilian awards. And the highest civilian award is the Bharat Ratna. Apart from this, we also have something called Padma Awards, Padma Shri, Padma Bhushan, Padma Vibhushan, like this. But whether it can be given or not. But otherwise, these civilian awards have been given by the government since the year 1954. But over a period of time, Supreme Court gave a green signal to go ahead. As long as these titles are not misused by the people who are the recipient of these awards. That's the reason sometimes you will also come across that the Supreme Court will give the order for revoking those titles, meaning anybody who is honored with any title, maybe Padma Award or Bharat Ratna Award, is expected to maintain the dignity of the nation, is expected to protect the dignity of the award, is expected to protect the dignity of the nation. So he should become a role model for the remaining people. But if he misuses that particular award, that can be withdrawn. They are very much permitted in India because the Supreme Court has given its notch. Am I clear? Now, let me open the document again. Now, so with this, we have seen articles 14, 15, 16, 17, and 18. All of them put together is called right to equality. And these are the things that are mentioned in the fundamental right. Number one, that is nothing but equality before law. Am I clear? And when we meet tomorrow, we'll discuss the remaining things. That is the right to freedom and all the things. We'll have a discussion. But kindly remember, whatever I told you just now, kindly recollect this. Every article I am going to touch once again. That is article 14, 15, 16, every article with the clauses and subclauses. But before that one, we'll have a detailed discussion regarding each and every article. Am I clear? So if possible, if there is a possibility, tomorrow, so I'll be completing this particular part. I'll be talking to you up to articles, whatever the articles that are available for us. And again, in the next class, we'll go back and start reading each and every clause that is present in each and every article in the fundamental rights. Okay. So thank you so much for being with me this morning. I wish you all the very, very best.